Good afternoon again. This is Chris DiOrio, and I'm talking to you from my palatial offices here in Quincy. Haha. We're going to talk today about a little bit more about the First Amendment, and I'm going to set it aside for a little bit. We'll wait for things to populate. What I want to talk about today is last week we talked about the Free Exercise Clause of the First Amendment, but this week I want to talk to you about the Establishment Clause. Establishment Clause of the First Amendment of the Bill of Rights, and how it addresses the balance between church and state. And there are a lot of different areas that this gets into. So if you have questions, by all means, chime in. But I want to get into just the basics at the outset, and then if there are things that come up along the way, then we'll discuss that. First, what does the Constitution say? What does the Bill of Rights say? Well, right there at the beginning of the First Amendment, it says, Congress shall make no law respecting the establishment of a religion. So then the question is begged, what does that mean? What does it mean that Congress shall make no law? First, you also have to recognize that the 14th Amendment, by means of what we call incorporation, also applies this to the states as well. Although there are a couple of Supreme Court justices who do not believe that this part of the Constitution should be extended to the states, that it is simply limited to the federal government, but that's more of a political issue than anything else. What does it mean to establish a religion? What did they intend when they talked about the establishment of religion? Most originalists will tell you that what they meant was simply that they didn't want the federal government to they wanted to prohibit them from establishing a state religion. That's really all the Establishment Clause was meant to do, was to prevent the federal government from saying, we do not have a state religion. We're not making a choice. They just fought a war over this, and they did not want to have an imposition of some sort of a federal church, a national church. Many of the countries over in Europe at the time had these churches that were supported by taxation. And they didn't want that here, and so that's what they did. Oddly enough, to look at it, this first statement, the first shot that they took related to religion, that the federal government, the Congress shall not establish a religion, was that body of Congress that ratified the Bill of Rights. Before they went in and did that, they were prayed over by a chaplain. And they prayed for their good works, and one of the very first things that they did after the ratification of this Bill of Rights was to allocate money for Christian missions to go into the Indian territories and proselytize to Native Americans. So to look at this as being an abject denial of all religious responsibilities is sort of running askew of what they actually intended. At an absolute minimum, it means that the federal government cannot create a religion. But it then has to address, what does the Establishment Clause mean? The federal government the Supreme Court didn't have to address what it meant until 1947. The case of Everson versus Board of Education dealt with a local school board paying parents for the costs of busing their children to parochial schools. The United States Supreme Court, in that decision, said that this wall of separation that the Constitution creates through the Bill of Rights should not permit, and the government should not be allowed to, A, prefer one religion over another, B, prefer all religions over none, and C, to prefer or aid one specific religion. And that was discussed and decided in this Everson decision. So there's three different things that they felt at a baseline that the government should not be involved in. That laws should not benefit religion over non-religion or prefer one over the other. And after making that decision, they then decided that it was okay for this money to be allocated to parents to reimburse them for sending their kids to parochial school for the buses. And the rationale there was that this was not supporting religion, that this was supporting what they referred to as a secular purpose of making sure that kids safely and expeditiously got to school. So even after setting the foundation, the boundaries for what religion was supposed to be and what we're not allowed to do as a government, certainly not what the Congress or states are allowed to do, they then went right ahead and allowed it to happen. So Everson is the baseline for what we look at. So when you're looking at a law that addresses something religious, understand that it's not always going to be looked at solely as a religious law. There's another test that has to be applied. But at a first glance, you have to look at it and say, does this particular law prefer all religions over none, or none overall? It does work in reverse. Secondly, does it prefer one particular faith over other faiths? There have been instances in the past where money was devoted towards Catholic schools and not to private individual schools, or private schools that are Christian but not, or Jewish or Hebrew schools, but they devoted money towards Catholic schools as well, purchasing books for them, and that was deemed to be a preference of one faith over another. So that's the first thing you have to look at. There is a test now that the courts use when they look at whether a particular law runs afoul of the Establishment Clause. You have, it's called the Lemon test. The case was called Lemon versus Kurtzman. Lemon versus Kurtzman dealt with public teachers having their salaries supplemented by going to teach remedial classes at parochial schools. And the court looked at that particular disbursement of money and rejected that, and created what now we know as the Lemon test, which has been modified over time. But the Lemon test requires three things. When you're looking at a law that might run afoul of religious establishment, you have to ask three questions. First, does the law apply to or have a secular purpose? By secular, I mean non-religious purpose. Is the reason for this law not religious? Secondly, the primary effect of this law cannot either inhibit or advance religion. So it may have a secular purpose, but if it may have a stated secular purpose, but if the primary effect of that law inhibits or advances religion, then you have a problem with Lemon. The third part of this prong, and one that, it's a three-prong test, and the third part is one that gets a little dicey in terms of interpretation. The law must avoid assiduously what they refer to in the language as excessive entanglement with religion. That's the baseline test that we have now. So when you see laws that are of this ilk, you have to then ask yourself, A, was the law promoted for a secular purpose? B, does the effect of this law have a primary effect, either advancing or inhibiting religion? And third, is this an excessive entanglement with religion? There are some ways, different ways to look at it. And I can give you some examples of laws that were upheld in terms of them being okay with the Establishment Clause based on this Lemon test. Case of McGowan, you ask questions about, well, what about Sunday closing laws? Massachusetts has blue laws. why they come directly from Sunday. I mean, we were not, they used to have laws that said you couldn't do certain things on Sundays. There's still laws here in Massachusetts regarding selling alcohol unless you have a certain specific license, only recently, and certain retail businesses that can't open until a certain hour. And they chose Sunday as the day. Well, why is this okay? Why are we, why is Sunday, a day that is normally looked at as the day of rest in the Christian faith, why is this the one that got chosen? And what happens is the court looked at this and said that it passes the Lemon test, because the law, when it was promoted, didn't refer to anything religious, and it referred to having what they referred to as a uniform day of rest, allowing for the scheduling of community activities free from the work conflicts predominated over any present-day religious purposes or effects. And so they allowed for the Sunday closing laws to take place. There's another interesting case for those of you musical theater fans or movie fans who remember the movie Footloose. There are many towns and cities throughout the United States that do, in fact, have bans on dancing. A town in Purdy, Missouri, their school district has a law against school dances. You're not permitted to dance. And it was promoted, in essence, it's a largely Christian community that dealt with this ban, and because of the worldliness of dancing. But in a federal district court case, this ban on dancing was upheld as having a secular purpose, even though there was ample evidence to show that there was no dancing policy was maintained in response to tremendous pressure from local conservative church groups. They allowed this as being a sufficient, as passing under the Lemon test. Another case regarding, and this is one that comes up a lot, prayers before, we have a government that says, and the First Amendment that says, we shall not establish religion. And yet, every term in Beacon Hill here, and in the United States Congress, and in many state legislatures across the country, and not just state bodies, but local bodies as well, where they permit and in fact encourage a prayer before they begin a session. Why is this allowed? Why is this not a violation of the First Amendment Establishment Clause? There was a recent case that came up, Town of Greece versus Callaway, Greece, Greece, that addressed this very specifically. And they talked about how this was allowable and that it did pass under the Lemon test. And under this, they sort of modified Lemon, said that basically it's not a violation of the Establishment Clause as far as prayers before public bodies begin legislative action, that it's not a violation of the First Amendment Establishment Clause if the prayer was part of a long established historical tradition. And we'll hear about that historical tradition when we talk about religious displays, especially here at Christmas time. But you have to show, A, that it's part of a long tradition, a historical tradition, 2, that there is no overt or covert discrimination against what the Supreme Court referred to as minority faiths. And third, that this prayer is not coerced, that you are not coerced into participating in the prayer. When pressed further on this, however, the Supreme Court used the term proper prayer, but they never defined it. So we're left now in an absence of information from the court as to what they considered to be a proper prayer. All they said was, in relation to this prayer, that it doesn't matter if the prayer offends people. It simply matters if the prayer is coerced. That the government isn't in the business and should not be in the business of what they referred to as coercing prayer. And that comes in when we talk about prayer in public schools. In 1962 in New York, they had a policy where there was, before the beginning of each school day, there was a written prayer that had been written by the school board and approved by the school board to be said before the beginning of school every day. And what they looked at was, in that case, it was in fact some degree of coercion to say the prayer because it was approved by the school board. The question there was whether the students were given the option, and they weren't, of saying the prayer. So the United States Supreme Court in 1962 in Engel versus Vitale said that the Establishment Clause is violated when the school puts what they referred to as indirect coercive pressure on religious minorities to conform to an officially approved religious statement. And that's what Engel dealt with. This was an officially approved prayer. The government, as was stated in Greece versus Callaway, is not in the business of, should not be in the business of creating, fostering, or promoting prayer, at least in terms of promoting it as a means of a coercive entity to make everybody pray. But what do you do with non-state sponsored, non-school sponsored prayer? If it's not an officially approved prayer the way it was in Engel, what do you do? Case in 1985 and many subsequent cases since regarding schools that promote what they referred to as, at the beginning of a school day, as a period of silence for meditation. This is a situation in Alabama, in the case of Wallace versus Alabama. They set aside a specific time each morning for kids to have a silent moment. That's what the original statute said. And then they threw something in, because it's Alabama, they threw something in that suggested that they also add in a period of silence for meditation or silent prayer. And as soon as they walked into that realm and talked about silent prayer, the United States Supreme Court, in a divided decision, 5-4, held that that amendment to that moment of silence law took it out of having a secular purpose. Remember that three-pronged test in Lemon. First, you have to have a secular purpose. Second, it can't inhibit, or primary effect of inhibiting or inhibiting or promoting religion, advancing or inhibiting. And third, that there's an excessive entanglement. So now you have to, address that. And that was because they added in that moment of prayer. Then it became an issue as far as violating that Lemon test. There was another case, the Weissman matter, regarding a prayer that they brought in a pastor to do a non-denominational invocation prior to a middle school graduation. But the court, in that respect, found the invocation and the benediction to violate the First Amendment. Justice Kennedy wrote the majority decision there and said that because it was at a time that was a memorial, milestone time for these kids, that you have them, they're reluctant to not participate. It was indirect coercion. And that, at that point, the Supreme Court found to be unacceptable. The degree of coercion there they deemed to be unacceptable. Basically, in general, when you're looking at establishment of religion related to schools and school prayer, the United States Supreme Court, at least now under its current composition, has demonstrated a willingness to strike down any laws that might be likely to be perceived as either coercive or a state endorsement of religion. One of the more recent cases about this was in Texas, dealing with they allowed a practice there in the Santa Fe district, school district in Texas. Yes, there's a Santa Fe in Texas as well as Mexico. But they had a policy there where students were allowed to elect other students, and these students were permitted to briefly, over the public address system before football games, make statements, to speak briefly. Traditionally, the speeches were always religious in character. In fact, the policy that created this election said that the speeches made by the students should solemnize the event but be sectarian in nature. The United States Supreme Court in that decision said that this school policy violated the Establishment Clause. The speeches were done at a school-sponsored event using school facilities, and most people looking in from the outside would observe this as being the school's endorsement of the prayers that the students were likely to be delivering as a result of this policy. So at that point, what you're looking at in terms of school prayer is it's a hard hurdle for anyone to get over in terms of what it is that you're looking to do. It's rare that you're going to have that type of entanglement, or that the court is going to allow that type of entanglement. I have a question here that I'm going to address in a second about Christmas trees and things of that nature, because we do have an issue related to whether religious speech or religious symbols in public places are permitted. And this is where it kind of gets a little, it can get a little silly. Because you look at certain arrangements in front of city halls or on public property, and you wonder, well, how is this allowed? To something certainly seasonally right now, Christmas trees and manger scenes and things of that nature showing up on city hall property, all the way to the more extreme question of, can we put a copy of the 10 Commandments inside courthouses? Can we put that on a wall? Can we put that on town property? These questions have been answered somewhat by the Supreme Court. And really the question there is, where do you draw the line? It's really how the court walks a tightrope here when it comes to where you draw the line. And there are differences between what is constitutionally permissible as a religious display, and sometimes it's very close to the line, and then there are constitutionally impermissible displays that are also very close to the line, and sometimes this division can seem laughably small and even silly, like I said. And basically what this comes down to, and I'm going to use the term that has been used since these decisions came down in the mid-1980s, as the two plastic animals rule. The case in 1984 in Pawtucket, Rhode Island, as a matter of fact, Lynch versus Donnelly, which dealt with the placement of a nativity scene on public property during Christmas. There's another tandem case that came, not really a tandem case, but a case that came out 5 years after that, regarding the County of Allegheny, Pennsylvania versus the ACLU. And both of them dealt with whether religious type displays or Christmas displays were permitted on public property. Lynch dealt with a manger scene that was placed on the grounds of the Pawtucket City Hall, which also had, along with it, a large Christmas tree right near the manger scene. In Lynch, the Supreme Court used that Lemon test that I discussed. And again, to remind you, Lemon says that it has to have a secular purpose, that it can't either inhibit the primary effect of this particular practice, cannot inhibit or advance religion, and third, that it has to avoid excessive entanglement with religion. So you might think that putting a display of Jesus in the manger out in front of City Hall would violate all three of these things, but the United States Supreme Court in Lynch versus Donnelly said no. They used that three-pronged test, and they concluded that the creche in front of City Hall did not violate the law. Why? Well, the rationale there was a little tortured when they dealt with it, but ultimately what they came down to was that because there was a Christmas tree there, and because the manger scene didn't just have the manger, that nearby the manger, there was a reindeer, a plastic reindeer, and a plastic snowman. And because the reindeer and the snowman were there, this then said, this resulted in them saying that this tree display was not a Christmas display in violation of religious rights, but was considered, and I'm going to use the term that came actually from the decision, that this was a mutual, neutral harbinger of the holiday season, because in this display there was a plastic reindeer and a plastic snowman. So adding these secular items to the display rendered it constitutional. Now you cut away 5 years later to the decision in Allegheny versus the ACLU. The ACLU brought an action against them. What they had was two separate displays. One was a manger scene right near the front door of City Hall, and across the manger scene there was a ribbon that ran across the manger that said Gloria in excelsis Deo. Right next to that manger scene was a 48-foot Christmas tree. And below that was a menorah display. Both of these displays were contested by the ACLU. The Supreme Court took each of them individually. They looked at the manger scene and said that the manger on the steps of the courthouse violated the Establishment Clause, because not only was it a manger with other animals nearby, the fact that they had this extended ribbon across it that promoted God, Gloria in excelsis Deo, that this then became a non-secular display. Then they moved over to the menorah and the tree. And what they said about the tree was, and combined with the menorah, that if they just left the menorah there alone as a display, that would have violated the Establishment Clause, as if the county of Allegheny was promoting Judaism as opposed to other religions. Go find another place where that would be a problem or even an issue. But the fact that they placed the menorah and that it was dwarfed by this 48-foot Christmas tree said that this was not a display for religious purposes, but that it was meant to display cultural diversity. And so, as such, it had a secular purpose that neither advanced or inhibited religion. And so they allowed the menorah and the tree, but the manger scene, that's out. So there's an odd balance when it comes to these types of religious displays now. So again, you're looking at that lemon test. Is it secular? Does it inhibit or advance religion? And is there excessive entanglement? And courts really don't like getting into excessive entanglement. When it talks, the question here, what about the reindeer was not Rudolph. It was just a reindeer. If it were Rudolph, I think you might have more of a point, but it was not Rudolph there. It was just a reindeer, along with Frosty the Snowman. So that's the tremendous defense there. But now you get into other areas in terms of displays. What other types of displays, or are we allowed to put a crucifix on top of a congressional or legislative building? Is that permissible? What about the Ten Commandments? That's one that's become more. In fact, there's a judge in Alabama who not only lost his judgeship but was disbarred as a result of fighting over this in the Supreme Court, etc. What can be allowed on public property without running afoul of the Establishment Clause. If you have a situation where, and the test here when it comes to these types of displays is it public or is it private? And I'll get into that in a little bit. Or right now, as a matter of fact. In 1995, the Ku Klux Klan, in a public square across from the Ohio State Capitol building, erected a cross, among other displays. But they erected a cross on public grounds. But because this is a private posting of this item, the United States Supreme Court said that private placement of this cross does not constitute a state endorsement of religion. And that's the key when you're looking at these other items as to whether they're allowed or not. That if it's done privately by a private organization on public ground, it is not considered to be a state endorsement. Again, it seems in these cases to run afoul of Lemon. But the key there is always, what do we do with a cross? It's quite obviously, a Christian symbol. And then what do you do with the Ten Commandments, which again is, considered a very much a biblical symbol. But what I would also say is this: if you walk into the United States Supreme Court chambers to argue a case before the United States Supreme Court, where the Establishment Clause is something that we promote in terms of First Amendment protections, inside the very chambers of the United States Supreme Court, there is a display of Moses taking the Ten Commandment tablets down the mountain. It's along the walls behind you. And in fact, inside the building, inside the United States Supreme Court, there is a statue of Moses, among others. And that's the key there. There's no preference when you're looking at this. It's not promoting Moses over others, because right next to Moses bringing down the tablets from the mountain, there is another fresco painted on the wall of the Roman Senate. And there's another, all different historical law sources are put there. So people have objected to going in and arguing in a place where the Ten Commandments are present on the walls of the United States Supreme Court, no less. But the issue there is that it's not promoting one; it's it's a historical display. But when you look at the Ten Commandments, that's one that is really starting to it's rearing its head again. There was a law in Kentucky in the 1980s that required that there was a copy of the Ten Commandments in every public school classroom, that it was placed on the wall. The United States Supreme Court struck down that placement because this was deemed to be a state or public endorsement of the Judeo-Christian faith and their system of laws. Just recently, in 2005, the Supreme Court decided two other cases, and the case of Van Order versus Perry gives a good sense of where the Supreme Court is now in regards to the Establishment Clause. There were Ten Commandments displays placed on public property. In one of them, there were Kentucky courthouses, and the Ten Commandments were placed on the walls of two Kentucky courthouses, and the ACLU brought action against that, and the court upheld that challenge. These framed copies of the Ten Commandments were taken down, or forced to be taken down, as an establishment of religion. However, the Fraternal Order of Eagles in Texas placed a large stone monument in front of the Texas Capitol building that represented the Ten Commandments. Why is that different? Well, in the Kentucky cases, the Supreme Court said that the placement of the Ten Commandments was motivated by the religious purpose of promoting religion. But in the Texas case, the court looked at that monument and said that this was a private organization, the Fraternal Order of Eagles, that there's a private organization that placed this on state grounds, and that it was done 40 or so years earlier, and that it was surrounded by other monuments. So contextually, what they said was that this monument placement had the primary and secular purpose of reminding viewers of the role of religion in shaping national values. So it has a secular purpose, but the secular purpose was religious in nature. This is where it gets confusing, like I said. Justice Breyer, who still sits on the court, and he's 78 years old and may in fact be off the court if he retires, in his concurring opinion provided that key fifth vote. It was a 5-4 decision. And he said that when looking at these types of cases, you have to have what he referred to as a nuanced examination of facts to determine whether the display has effect that is inconsistent with the values expressed in the Establishment Clause. So that's when you're dealing with religious monuments and things of that nature, one of the questions that you have to look at is this is it a public or state endorsement of it? Does it have secular purpose? If it does have secular purpose, then you have to let them know. If it does have secular purpose, if it has a secular purpose, then you go to that next level. Does it advance or inhibit religion? And again, the law from Everson, where Justice Black wrote the Everson decision, as well as Lemon, comes down in the same area. The First Amendment Establishment Clause is you're not allowed to either promote one faith above others, to promote all faiths over none, or to promote no faith over others. So that's the baseline standard. And then you look at Lemon in terms of its secular nature and the secularized test that it places. And you now look at each individual practice as to whether it violates that test. Lemon has been nuanced over time to discuss this aspect of whether, in fact, it's permissible in terms of the inhibiting or advancing religion portion. They still try to avoid excessive entanglement at all possible. So that we've talked about school prayer. We've talked about invocations and things of that nature. We talked about religious displays in front of public buildings, around public property. And one of the last area I want to discuss with you is intelligent design and evolution, and whether they are permitted or should be permitted to be taught side by side in schools. Everybody has their own sense of creation, how we got here. The Egyptians believed that there was a primeval ocean, and the ocean was Nun, N-U-N, and that Amun-Ra was birthed from this ocean. Amun-Ra then masturbated into the ocean and produced 2 kids. And they bred a race of gods, and Amun-Ra's tears, because these kids ran afoul of him, Amun-Ra's tears became mankind. India has a belief that Purusha sacrificed as an act of creation, was sacrificed as an act of creation and was cut apart, and Purusha's head became the sky, that her feet became the earth, that the sun was her eyes, and the moon was Purusha's brain. The Bible, of course, refers to Genesis. Genesis 1:26, in the beginning. China discusses the Pian-Ku, where Pian-Ku was hatched from an egg, and then grows taller. And as he continues to grow taller, his shell stayed on his head, and he separates himself from the earth. And the shell going up creates the sky, the dome of the earth. However, Pian-Ku had a hygiene problem, apparently, and had a number of parasites that crawled all over his body, which he then washed himself of. And these parasites became humanity. The Greeks, ancient Greeks, believed in that all was chaos before Gaia birthed the sky, and that Gaia produced the Titans, and that the Titans became the Cyclops, and they banished all, Cronus, and Cronus cut off his father's testicles and then ate his own children. They're all, and then we have the Big Bang, that at some point in billions of years prior, there was an explosion, and that explosion out in space, it created and spun out into a universe, and planets being formed from gases and star stuff and things of that nature. And then from that Big Bang, we have, a guy who, argues over soup in a deli. This is where we're at. All of these different ideas of creation. And the question then becomes, in terms of schools, why promote one over the other? Doesn't this then violate the Establishment Clause if you prefer one or the other? Again, you're looking at that lemon test, and the history of this is, amazing. And many of you know the history, and some of you don't, in terms of what, evolution is allowed to teach, or what happened in the history of evolution. There was an idea up until 1925 that evolution should not be taught in schools, that only creationism was to be taught. In fact, there were laws that prevented evolution from being taught. One man in Tennessee by the name of John Scopes, he was a high school biology teacher, taught evolution in class, and he taught it in violation of the state law in Tennessee, and he was prosecuted as a result. This led to what we refer to in the common parlance as the Scopes monkey trial, because the idea in evolution being that we've evolved from lower forms of life into apes and monkeys, and from that we evolved into the humans that we are. A tremendous trial between William Jennings Bryan and Clarence Darrow, discussing the merits of religion in society, and discussing the merits of religion in terms of teaching creationism. What people don't necessarily know is that Clarence Darrow, one of the great lawyers of his time, lost. The Tennessee law was upheld, and Scopes was prosecuted, and he was punished for teaching evolution. You cut away 40 years later, however, into 1965, when a woman by the name of Susan Epperson did the exact same thing in an Arkansas school. She herself was a high school biology teacher, and she was prosecuted for teaching evolution in schools. The United States Supreme Court, in Epperson versus Arkansas, said that this law promoting creationism was in fact unconstitutional, that you cannot forbid the teaching of evolution strictly because it runs afoul of a Judeo-Christian belief in Genesis, that the law related to evolutionary teaching and banning it in favor of creationism was a direct affront to what they understood to be an Establishment Clause case. It was in fact a law that was not promoted for a secular purpose, that it did in fact inhibit or advance one particular religious belief over another, and third, that it was an excessive entanglement with religion. It violated all three parts of the Lemon Test, and therefore the law regarding the prohibition of teaching evolution was stricken. As a result, evolution was taught, and over time these laws continued to fail. They are continuing to come back out now, however. And we are seeing the change of creationism into the more palatable, somewhat, term of intelligent design, and requesting or passing laws in local school districts in the South mostly, trying to say that intelligent design should be taught alongside evolution because evolution is a theory and so is intelligent design, and to promote evolution and to not allow the teaching of intelligent design also violates the Establishment Clause because, as we remember from discussing Everson, you can't say no religion over all. And under the Lemon Test, you cannot inhibit religion as a result of what you're doing. So this creates the conundrum that we're going to have to deal with over the course of the next few months and years. And again, considering the potential future composition of the United States Supreme Court, there's no guarantee right now as to which way this will go. States cannot mandate the teaching of creation science because the purpose of the law is to promote religion. So that's where the line gets drawn. There's a question here. In public schools, there are Hanukkah and Kwanzaa songs, decorations, but not songs for Christmas. As I said previously, practices that they engage in schools cannot advance or promote one religion over others, cannot promote all religion over none. If they're not specifically allowing Christmas songs, but they are allowing other religious displays, then that might in fact run afoul of what they're doing. If they allow all of them, however, then it's considered inclusionary and is not promoting, it's not promoting one over the other in terms of the Lemon Test. Let's see. What other questions are there? If there are any, this is all I have for you now. Hopefully I touched on all the areas that I said that I would. If I haven't, please remind me. But again, thank you for checking in. I'll let it sit for a little while to see if there are any questions that you might have. But what I want you to get from this and what you should understand as a result of today is that in terms of the Establishment Clause, the original idea, the original intent was to prevent the federal government from promoting or creating a federal religion, similar to what they had in Europe at the time of the Revolution, where there were state taxes that would promote particular churches. But more to what we look at now in terms of establishment, the idea is that the government cannot be involved in excessive entanglement with religion, that you can't have a law that promotes one religion over others, that you can't have a law that allows for excessive, unnecessary entanglement, and that it can't promote or inhibit the law. One thing that people forget about and that they lose track of, and I'm going to find my notes here for a second because I want to make sure I get this right. Simply because a law has a potential religious starting point, for lack of a better term, just because there's a starting point that addresses religion does not necessarily mean that it is a religious law. If that were the case, one might argue that there should be no laws against murder, that there should be no laws against adultery, that there should be no laws against a number of other constitutionally prohibited practices. But we have them. We do have them. So what you have to ask yourself is, why do we have them? Just because a law is consistent with a religious belief and that religious belief comes from a legislative majority is not necessarily rendering it violative of the Establishment Clause. We are not, although some would have us believe, we are not a classic theocracy. We are not what certain Islamic countries are, where they base a large portion of their law on specific religious texts. We are, however, in terms of majorities and looking at who practices what, we are a predominantly majority Christian nation. That doesn't mean that that's our sponsored religion, but in terms of the number of people who practice Christianity, that's what we are. Difficult questions are presented by laws which have at their base a strong religious purpose, or when you look at these purposes, there's also at least the state has to have some secular justification for the act in question. That's really what it boils down to. If they can address some sort of, or apply some sort of secular balance or secular reason for a particular law, then they're permitted. But understand that this is not a promotion of a theocracy. And that's where we run into danger, where we begin to allow for decisions specifically to be made as a result of adherence to a particular religion. One last thing, and I know this was asked last week, and I want to, in terms of free exercise, as far as atheism and secular humanism is concerned, there's no real protection there because there's not a matter of ultimate concern when it comes to atheists. There's no specific practice. But more to the point, when you're talking about secular humanists and the Establishment Clause, they are protected. From an Establishment Clause standpoint, it doesn't matter whether secular humanism is a religion in any deep philosophical sense whatsoever. The only question is, does this particular group have beliefs about religion? And that also applies to atheists as well in terms of the Establishment Clause. The key question there is not whether secular humanists or secular humanism is a religion, but whether they are equally treated, whether secular humanists are treated equally as a direct component of discrimination on the basis of religious belief. That's not permitted. Discriminating against someone based on religious belief is not permitted under the Establishment Clause. It violates Everson and the all versus none rule. It violates Lemon. Specific discrimination against someone because of their religious belief is not permitted, and it goes both ways. Any discriminatory treatment of people who reject religious beliefs is still discrimination. It's discrimination on the basis of religion or the absence thereof. Much the same way as discrimination against people who refuse to support a political party or political ideology is a discrimination based on their political belief. The Establishment Clause forbids discrimination in favor of religion against irreligion or unreligion or non-religion, as well as in favor of one religion over others. So secular humanists are protected in terms of, and atheists are protected under the Establishment Clause. The Supreme Court dealt with this. Justice Black, who wrote the Everson decision back in 1947, also addressed this same question again. And I'm going to use his language very specifically to top things off. We repeat again and again and reaffirm that neither a state nor the federal government can constitutionally force a person to profess a belief or a disbelief in any religion. Neither can they constitutionally pass laws or impose requirements which aid all religions as against non-believers, and neither can they aid those religions based on a belief in the existence of God as against those religions founded on different beliefs. It makes no difference whether a law discriminates in favor of theists versus atheists, or secular humanists, it qualifies as favoring religion over non-religion. That's the baseline. If you discriminate against these groups based on how they perceive faith, how they perceive religion, you are in fact engaging in discrimination. these same legal principles that protect Christians, that protect Jews, that protect Muslims, that protect Baha'is, that protect Buddhists and Confucianists, and all of these same legal principles protect secular humanists as well as conventional religious believers. Atheism, to some, is not a religion as far as in defining it conventionally. And not all atheists are secular humanists, and not all secular humanists are, in fact, atheists. But as far as the Establishment Clause of the First Amendment is concerned, it doesn't matter. It doesn't matter whether you're an atheist or a secular humanist or any other belief system that takes a position on a religious issue. Doesn't matter. People who reject religion or are simply indifferent to it can still be discriminated against on the basis of their beliefs about religious questions or the lack thereof. That's it. I hope folks got a little bit of education out of this, and we're going to take a couple of weeks of break from ChrisChat over the break here, and we'll notice I'm not calling it a Christmas break, haha. But unless people have questions, I'm always willing to answer them, and you can always pose them to me, and I'll be here to answer them always. But thank you very much for tuning into this week's ChrisChat, and if you have suggestions for future topics, I do plan on talking about the Muslim registry soon in relation to both free exercise and establishment. If folks want that done before the holiday, I'll do that, but otherwise I'll hold off on that until before the election. But that's where we'll go going forward. If you have suggestions about what you want me to talk about or areas that you want me to get into, search and seizure issues, things in the criminal law, things regarding equal protection, other areas of the civil rights and the Bill of Rights, please let me know. Send me a message. If you're already on my friends list, you can certainly do that. But again, it's my privilege to be able to sit here and talk to you, and I'm thankful that you do sit in and listen, those of you who have chimed in. I'll post the video very soon for public consumption if you wish to share it, or to review it later on if there's anything that you missed. Again, thank you very much for chiming into ChrisChat, and we'll see you soon.